Resumption of debate on the Criminal Law Temporary Provisions Amendment Bill, second reading.
Mr. Lewis Ng.
Sir, the need to extend the CLTPA every 5 years is an important safeguard, which ensures parliamentary scrutiny to ensure that there is continuing need for the executive to exercise the exceptional powers under the CLTPA. It bears reminding that the power to detain without trial under the Act is a significant exception to the fundamental rule of law principle enshrined under Article 9 of our Constitution, that no person should be deprived of liberty without a fair trial. Indeed, during the second reading debate in 2013, when the Act was last renewed, Minister Iswaran provided the guarantee that, quote, the government will always make a rigorous case based on a thorough assessment of all circumstances and the criminal landscape each time we seek Parliament's approval to extend the CLTPA, end of quote. While I understand the continuing public order and security pressures that justify the exercise of these powers, we should never forget the extraordinary nature of the CLTPA and closely examine the grounds for the Act every time it comes up for renewal. My Facebook post seeking public feedback on the bill has generated a fair bit of comments. These amendments clearly concern many Singaporeans, and I'd like to raise 4 points for clarification, many of which come directly from members of the public. The first point was about the judicial review, and I'm glad the Minister has clarified this in his speech, and that will allay a lot of the concerns on the ground. My second point is on the advisory committee. And can the Minister provide information on the number of cases over the past 5 years in which the advisory committees made a recommendation not to detain, but this recommendation was not accepted? If this has happened several times, my concern is that the objective of an independent advisory committee is undermined if a significant number of recommendations to not detain are ignored. Why might a decision be made against adopting recommendations of the committee which would have made its recommendations after scrutinizing the investigations and documentary evidence, hearing the detainees present their cases, and examining the detainees, investigating officers, and witnesses? Can the Minister provide some examples as to why a recommendation is not accepted? Also, where its recommendations are not accepted, can reasons be publicly made for such a decision? Next, another question raised is, why is there a need for the CLTPA to cover offences under Schedule 4 when these are already dealt with under their respective legislation? During the last renewal of the CLTPA, Minister Iswaran, and today Minister Shanmugam as well, had explained that the CLTPA is intended to complement the other legislation, like the Organised Crime Act and Misuse of Drugs Act, by addressing situations where it is not possible to prosecute persons in court because witnesses are fearful or unwilling to testify. One suggestion put to me is whether the other legislation can be amended to address the difficulty in securing witness testimony in open court. Has the Ministry studied other options for addressing this problem, which will lessen the need to rely on powers under the CLTPA? Next, the current Section 33 and 34 set out the restrictions on persons subject to the police supervision order. The bill amendments were the effect of moving these restrictions into subsidiary legislation. Many of these restrictions involve significant limitations on the individual personal liberty and freedom of movement. These include restriction of place of residence, reporting requirements, restriction on leaving Singapore, and curfew requirements. The rationale provided is that this provides the Minister more flexibility to impose obligations and restrictions on CLPS. Given how intrusive some of these measures may be, it would be more desirable for these restrictions to remain under the Principal Act, where it can be subject to legislative scrutiny. Can the Minister elaborate on the circumstances that have prompted the move of these restrictions into subsidiary legislation? Are there specific situations in which these powers have proven to be inadequate in providing supervision, and what are some of the examples of further powers that may be additionally required? Lastly, the new Section 47(5)(a) will extend police powers to investigate an arrestable offence under Section 33(3) to CNB officers. As I raised during the second reading of the Immigration Amendments Bill last month, extending police powers to ICA officers and now CNB officers are expansion of executive powers that should always be done cautiously. Can the Minister clarify if these amendments were prompted by challenges faced by the police in responding adequately to Section 33(3) offences? So I note with appreciation the government's repeated assertion that the powers under the Act will be exercised judiciously. In the spirit of public safety, peace and good order, I stand in support of this bill, but I urge the government to exercise its powers under the CLTPA with great restraint, to provide full grounds for detention, to take into account recommendations of the advisory committees, and to also provide reasons where their recommendations are not accepted.